Hello, ladies and gentlemen. It is Hoystory on Air, Season 2, Episode 19. It is Monday, May 11th, 2026. Today we are going to be talking about the Virginia redistricting and the fallout from there after the state Supreme Court went and shot it down. Lots of braying and gnashing of teeth and frankly, lying has been going on in the aftermath of that. Before we get to that, you can go over to hotair.com. That says Ed Morrissey up there. If you scroll down, it actually says Matthew Hoy. This is an excerpt/adaptation of my book, Fact Checking Frauds. Up there, QR code if you want to buy it. Please buy a copy. The Kindle edition is only $5, $4.99. But buy a print one too. Fun for the whole family. But the excerpt there, will AI become the next fact check tool used to censor conservatives? Gives you a taste of what's in the book. So let's move on to Virginia redistricting. At the top is what the map looked like before the recent vote and what it looks like now. There are 6 Democrats and 5 Republicans. Below is the one that got tossed out because the Democrats cheated on the process. Okay? That would have been, as you can see, 10 Democrats to 1 Republican. This is from the... Roscoe has come here. So we'll see if Roscoe behaves or not. This is from the ruling from the Virginia Supreme Court last week that struck down this new gerrymander, or Gerrymander is probably the proper pronunciation. And it says basically the way they in their ruling they lay out, and we're going to have to delay this because I have cat being a problem. Let's see if he gets out of here. I wish I had a door. Buy my book. I will buy a door to keep out the cats. Don't have a door here. They basically lay out what the process is to amend the Constitution. Any amendment or amendments to this Constitution may be proposed in the Senate or House of Delegates, and the same shall be agreed to by a majority of the members selected to each of the 2 houses. Such proposed amendment or amendments shall be referred to the General Assembly at its first regular session held after the next general election of members of the House of Delegates. They write, under this provision, the General Assembly can propose amendments but cannot adopt them. The inverse is also true. Virginia voters can adopt or reject amendments but cannot propose them. This constitutional amendment process of dividing power between the people and their politicians has withstood the test of time for more than 100 years and has remained so for the half century since Coleman. Coleman changed some rulings or whatnot. So they write, to guard against hasty changes to the Commonwealth's organic law, Article 12, Section 1 also slow walks the constitutional amendment process. The General Assembly must twice vote in favor of a proposed amendment at 2 separate legislative sessions with an intervening election of the House of Delegates. This gives voters 2 opportunities, one indirect, the other direct, to voice their views on the proposed amendment. The first is during the intervening election period between the 2 legislative sessions. Voters can support or defeat candidates for the House of Delegates who either endorse or oppose the proposed amendment. If the General Assembly votes against it at the next legislative session, the process ends there. If the General Assembly votes in favor of the proposal, voters get a second direct opportunity to vote the proposed amendment up or down at the ballot box. The efficacy of the second popular vote depends in part upon the reliability of the first. The reasoning behind this, Delegate Slaughter stated in 1969 during the General Assembly's debates over the later 1971 amendments to the Virginia Constitution, is that constitutions should not be changed lightly. That's the way it works in Virginia. Okay? That's the way they have set up. The politicians in the past made that choice, and the people ratified it. You can debate whether this is good or bad. What you can't debate it over is whether this is the process. The majority again wrote, in this case, voting in the general election for the House of Delegates began on September 19, 2025 and ended on Election Day, November 4, 2025. The General Assembly voted for the first time to propose the constitutional amendment to the electorate on the October 31st, 2025. By that date, over 1.3 million votes had been cast in the general election, which was approximately 40% of the total vote for that election cycle. Now, for the record, I am a big proponent of you vote on Election Day, unless you have a reason, unless you have a valid reason, like you're going to be out of town. So, for example, my niece is graduating from high school on June 3rd. The primary here in California is on June 2nd. I will not be in town, nor will my wife be in town on June 2nd because we're heading down to see my niece, who is valedictorian. Good job. Graduate from high school. So, having said that, that's a good reason to get an absentee ballot and vote ahead of time. Being able to vote, that's practically 6 weeks, ladies and gentlemen. Voting began September 19th. It's 6 weeks later is the actual election day. That's when you count them all. And that's part of the debate here. But lots of people voted not having the slightest inkling that the Democrats were going to include this constitutional amendment on the upcoming ballot the next year. Not allowed to do that, according to their Constitution. That's what the Constitution says. Democrats don't like this. Tim Kaine, their senator, made a statement. This is from Igor Bobik, who's a lefty on Twitter /X. The timing of this ruling speaks volumes. If the Virginia Supreme Court had legitimate concerns about this referendum, the time to stop it would have been before 3 million Virginians cast their ballots. He goes on. The U.S. Supreme Court, this was, a week and a half ago, the U.S. Supreme Court said, the Voting Rights Act basically says you cannot gerrymander on the basis of race. And that's what they were doing. They were there were lots of states, and they were being required by state courts under the Voting Rights Act to create districts that were almost sure to elect a minority. Typically black, sometimes here in California it's Hispanics. Supreme Court says you can gerrymander for politics, you can't gerrymander for race. So he says the U.S. Supreme Court eviscerates the Voting Rights Act in a lawsuit brought by a January 6th extremist and southern states race to craft backroom deals disenfranchising minority voters and candidates. Meanwhile, Virginia voters choose to stand up against national disenfranchisement only to see their votes cast in the trash by a 4-3 ruling. Now, just for the record on this 4-3 ruling, before we get too much to it, 4 of the justices on the Virginia Supreme Court were put there by Democrats, 3 by Republicans. This failed because one Democrat was honest enough not to play the political game. Because the Virginia Constitution is really clear. The other ones who are playing this game, the Constitution in Virginia is set up so that, again, so it slow walks it. So voters have a couple of chances before they decide on changing the Constitution. The liberals, the Democrats, not acting very liberal, frankly, on the Virginia Supreme Court in the 3-person minority, basically would have been fine with the vote, letting you know that, hey, we're going to have this redistricting. They could have passed that the day before, on the Monday before the election day, and those 3 would have said that's just fine. how do you know what you're voting on? If we can change the rules and we can put something on there the day before, and that meets it obviously didn't meet either the spirit or the letter of the law, but they go and play this game. So Kane plays this game about, it's the timing of it. They should have ruled this way. They should have done this ruling before people went to vote on it if the process was illegitimate. That's something that occurred here. The Hill reports on Ted Lieu appearing on Face the Nation, saying that the timing on this in the ruling is disgraceful. And here's him on Face the Nation. We'll take a look at this here, and I want to draw your attention to a couple things. And just listen. We'll start with just listening.
But that Virginia push by Democrats, you spent more than $60 million on that redistricting effort. Wouldn't those funds have been better spent on those frontline candidates and arguing on the issues?
Yeah. So what the Virginia Supreme Court did was not only wrong, it was disgraceful. They basically said, hey, Virginia, spend all this taxpayers' money holding an election, do all this stuff, and oh, by the way, just kidding, that election didn't count. The court could have stopped this by not having the election in the first place. They suckered the people of Virginia. It was a complete disgrace. Now, most of the money that Democrats spend in the race is called C4 money, so that's not direct hard money that we're going to need for races in the midterms. But it was taxpayers' money that was wasted because of the disgraceful opinion by the Supreme Court.
You think it was worth the financial cost? I mean, are Democrats going to somehow continue to fight this in court?
We're going to look at all available options. We're definitely going to try to keep fighting this battle. And I just want to note, the best way, again, if someone shoves you down, is to get right back up and fight back, and that's what we're going to do. And of these 4 seats in Virginia, we believe we're going to win 2 of them in the midterms, and that's what we're doing. We're fighting back.
There's a couple problems here, and we'll get to these points. First off, the reason why the Virginia Supreme Court did not rule on this before the election was because the Democrats went to the court and said, you can't, because there's a 100-year-old ruling that says if there's a procedural dispute, that happens after the vote. So quickly, this is typical of what you're getting around the country. Ted Lieu's a Californian. What's he give a damn about Virginia about? Well, just because it's Democrats. This is Catherine Clark. She is a state representative or senator, I'm not sure which exactly, don't care which, in Massachusetts. And she is a lawyer. And she's, if the standard applies in Virginia, it should apply in Florida too. Two different standards for democracy is not justice. Ladies and gentlemen, the Virginia Supreme Court ruled on the law in Virginia. It's different in Florida. It's different in a lot of these states. You can't. Why are we wanting the Virginia Constitution to apply in Florida? Well, because Democrats done screwed up. Here's the April 21st redistricting referendum. The Supreme Court of Virginia today confirmed that Virginia's redistricting referendum will proceed as scheduled on April 21st, 2026. In its order accepting expedited review of Nardo et al. Versus McDougall et al., the court found that given the limited scope of the Tazewell County Circuit Court's injunction, its ruling has no effect on the referendum scheduled for April 21st, 2026. Elias Law Group is proud to represent House Speaker Don Scott, who intervened in this case to defend the General Assembly's effort to put a redistricting referendum on the ballot. Ladies and gentlemen, that is Mark Elias. He is the Democrats' election lawyer. He will sue anywhere, anytime, and he is touting, hey, we got the Supreme Court to let the vote go ahead of time and not hear these problems about the process until afterwards. The attempt here was to create a fait accompli, and that's what they were trying to do. Again, from the ruling, it's fair to ask whether we could have, or should have reviewed the constitutionality of the proposed amendment prior to it being presented to the voters. But it is not a question the Commonwealth should ask. Throughout this litigation, the Commonwealth has insisted we cannot lawfully decide this case prior to the referendum. In its motion for a stay in this case, the Commonwealth argued that long-standing Virginia precedent, Scott versus James, was virtually indistinguishable from this case, and that it clearly held that courts cannot interfere to stop any of the proceedings while this permanent law is in the process of being made. And only upon completion of the proceedings, if the validity of the amendment is assailed on the ground that several provisions of the Constitution have not been complied with, then the courts can pass upon the validity of the amendment. Okay? So, it's absolutely maddening and dumbfounding that, no, you can't do that, and then, okay, well, you're right, the law says that we cannot stop it before, we cannot stop it because of procedural problems that you guys have created until after it's run its course. And the majority then says, having successfully insisted over the objection of the claimants that we postpone judicial review of the constitutional amendment until after the election process, it might be tempting for the Commonwealth to think that the final vote implicitly stacks the deck in its favor. Perhaps enough so that the exercise of any judicial review could be viewed as an ultra vires effort to overturn the will of the people. If this supposition were true, that Scott forbids pre-election challenges and that the will of the people forbids post-election challenges, then judicial review of allegedly unconstitutional procedures used to adopt a constitutional amendment would not exist in the Commonwealth of Virginia. Yeah, they're trying to have it both ways. They were trying to create a fait accompli where, the people have already voted and you're bad if you overturn it because of these irregularities. This is audio from the oral argument hearing this case after the election. Take a listen.
Article 12 requires. As a result, the proposed constitutional amendment has been ratified and is now part of the Virginia Constitution. The Circuit Court attempted to interfere with that democratic process by halting it. This court properly put a stop to that. The challengers here now try to overturn the results of that democratic process. This court should not countenance that either.
I don't understand that as a legal argument, given that you asked us to invoke our, ironically enough, named Scott decision from over 100 years ago that specifically says you don't deal with any potential procedural irregularities before the people have voted. So saying that the people have voted yes after having said you don't even look as to whether there's a procedural irregularity after it's voted doesn't add anything to the equation, does it?
No, and to be perfectly clear, we're not arguing that this court lacks jurisdiction to review whether the constitutional requirements of Article 12 have been complied with. It does. Instead, I'm saying that on the merits, this court should not accept the challenger's arguments.
But the fact that there's a yes vote doesn't tell us anything about those merits.
No, it does not.
Okay.
So that was the Democrats' lawyer on this, the Commonwealth's lawyer, admitting that, hey, yeah, I mean, he's trying to have it both ways, just saying, hey, wait a second, you can't do that, honestly. You need to follow the rules. Democracy, we get this democracy, we're saving democracy. Well, you need to follow the rules. They didn't want them to, and the date is tomorrow. The person who runs elections in the state of Virginia says, look, I need to have this set by no later than May 12th, or I'm going to have problems determining, who is in what district and who they get to vote for and all that other sort of stuff. May 12th, that's the deadline. And so last week, Jay Jones, the bloodthirsty Attorney General of Virginia, who wants to kill Republicans so that they will come to see the light and vote his way on policy issues. He goes to the Supreme Court and says, hey, don't issue your mandate because we're going to go to the U.S. Supreme Court. Don't have a prayer. Do not have a prayer. But in his rush to do that, here's the thing he filed with the Supreme Court of Virginia. There's another Virginia state senator. Can't even run spell check. That's how incompetent this idiot is. So over the weekend, the Times, New York Times, exclusive private call reveals Democrats' desperation over tossing of map. A conversation involving House members from Virginia and the top House Democrat reflected the fury and desperation that has gripped the party after Friday's ruling in the state. So let's look at this, because this is, we must destroy, this is the height of, we must destroy democracy in order to save it. It's frankly embarrassing. Democrats are struggling to respond to a major redistricting setback in Virginia, with some party leaders discussing an audacious, and possibly far-fetched idea for trying to restore a congressional map voided by the court, but showing little indication they have a clear plan. Ladies and gentlemen, if this were Republicans and the state Supreme Court had said, no, you can't do it, and they were discussing an end run around that, they wouldn't be characterizing this as audacious and possibly far-fetched. It would be outrageous and illegal. The way they are kind of sugarcoating this is typical of what you would see from left-wing media defending left-wingers. During a private discussion on Saturday that included Democratic House members from Virginia and Representative Hakeem Jeffries of New York, the minority leader, the lawmakers vented anger at their defeat at the Virginia Supreme Court, spoke about a collective determination to flip 2 or 3 Republican-held seats under the existing map, and discussed a bank shot proposal to redraw the congressional lines anyways. Bank shot? Bank shot? Illegal as all get out. Outrage, affront to democracy maybe. But again, the New York Times is going to sell this, try and soft sell it, so it doesn't seem as outrageous and illegal and odious as it is. According to 3 people who participated in the call and 2 others who were briefed on it, the conversation reflected the desperation and fury that have gripped the party after the state Supreme Court struck down a favorable map that had been ratified by voters. The most dramatic idea they discussed. Let me jump back a second here. I want to point, I forgot to mention this, and I want to mention this before I get too much further ahead. This complaint that the voters have spoken and the Virginia Supreme Court was wrong to overturn this after the fact. Despite the fact that Tim Kaine and all these other Democrats and Ted Lieu, the fact that they are making these claims and the press is, the fact they're making these claims and the press isn't calling them out on it, that Margaret Brennan didn't call him out on, they should have stopped this before if they had a problem with it. The fact that she was unwilling or didn't know enough to say, well, but Representative Lieu, Democrats wanted it that way. They could have come before the state Supreme Court and said, we want you to rule on it now so we don't spend the money if we've done it wrong. They could have done that. They could have said, we want you to overturn that 100-year-old decision saying that you don't do rulings on procedure until afterwards. We think that that's bad law and you should change it. They could have done that, and they didn't. And allowing Democrats to get away with that is, again, it's the left-wing media just going along with it. The most dramatic idea, getting back to this, the most dramatic idea they discussed, which would involve an unusual gambit to replace the entire state Supreme Court with the goal of reinstating the gerrymandered map, drew mixed reactions on the call. Not clear it would be viable or palatable. Like, we don't like these. If you don't like my principles, I'll come up with some others. If you don't like these judges, we'll come up with some others. It's embarrassing. One key to the plan would having Democrats in Richmond lower the mandatory retirement age for state Supreme Court justices. Now, in order to do this, and this article does not say what they would have to do there, but in order to do that, how far would they have to lower it? Well, Shipwreck Crew on X says, current ages of 7 justices on the Supreme Court are 70, 69, 67, 64, 51, 56, 54. If they're going to do that, they need to lower the retirement age to 53. Okay? And then they would install 7 new justices, would have to commit to advance into reversing the court's decision. Does this sound like, does this sound like Venezuela? Does this sound like what Hugo Chavez did with the Supreme Court down there? This is real banana republic stuff. But that's what they were considering. That's what there's, and it gets better. Okay? It gets better because who would they have to sack? They'd have to sack the first black woman Supreme Court justice in Virginia. Not a good look. Not a good look. I'm hearing rumors that this plan may die. Well, good. It is dumbfounding that this was even considered. But you continue down the article, and this is where I posted a brief short on all the social media that I participate on about this. But this is something that if we had fact checkers who were dominated by right wingers, this is something they would fact check. We have a representative, Suhas Subramaniam, who's a Democrat who represents Loudoun County, Virginia. That is the county that is notoriously pro-trans and anti-little girl, and are all for raping little girls or allowing trans people to rape them because you don't want to hurt trans people's feelings. So he represents that county. We shouldn't be surprised there. He says, everyone's got to have a strong stomach right now. This is a complete disaster waiting to happen if people are timid. Okay, so he's one of these guys who's apparently supporting the idea of firing their entire Supreme Court. And he says, and this is the claim, fact checkers, fact check this. We have Republican states ignoring their constitutions and interrupting early voting and ignoring their Supreme Courts altogether. We know that based on that, Republicans would explore every single option possible to move this forward. Say, well, the other guys would do it. And that gets back to that, Massachusetts representative or senator saying, oh, well, the same rules should be in Massachusetts, should be in Virginia, should be in Florida. No, these are called states. And fact checkers, is this claim true? Are Republican states ignoring their constitutions and interrupting early voting and ignoring their Supreme Courts? Are they? I went and asked Grok, are there any Republican-controlled states that have violated provisions of their state constitutions in order to do mid-decade redistricting? And Frank, I saw this going on. I have never seen Grok think for this long before giving an answer. A minute and a half. That's a pretty long time. And the answer is no. Now, people have filed lawsuits. Supreme Courts have said this is okay or not. But what Representative Subramaniam has said, according to Grok, is false. Now, I don't always trust AI. I think it provides a starting point sometimes. Fact checkers, fact check this. Is this true? I want to know if this is true. This is a topic of intense political debate in the United States right now. This is a claim that we should probably check. Is anybody going to check it? I'm not going to hold my breath. I'm not going to hold my breath. It should be fact-checked. It's not. Why? Because they're a bunch of frauds. Again, QR code for my book is right there. Select it. Go buy my book. You'll see more of these games they play. Fact checkers play. This whole incident is an embarrassment. And when they, and frankly, you read and there'll be a link to it in the show notes. You read the dissent in the Virginia case, the three judges who dissented, and it's a reach. And frankly, that's the reach they're going to the Supreme Court with, is that, oh, well, as long as it's before Election Day, again, you can do it the day before. As long as it's before it, because we have Election Day. If the Supreme Court were to take it, they're not going to. Although I'm going to love to see the Ketanji Brown Jackson dissent for them not taking it, because I'm sure that'll be a hoot. You'd have to invalidate all early voting. All early voting is, forget about it if that's what they want to do. That's kind of what they're asking to say. That any early voting, any mail-in vote, not sure mail-in, but definitely any early voting is invalid. They would rather disenfranchise 1.3 million people who voted early, not to mention, roughly equal representation from a state that, was touting that, to get Trump. They're willing to kill democracy to save it, and that is a sad thing. Again, follow me on the social media you see there. Buy my book. Tell your friends about my book. Don't have any podcasts lined up just yet, but some more podcast appearances where people will ask me intelligent, insightful questions about my book are coming up. So make sure to follow me. That's how you're going to find out about those. And thank you for joining me today. We'll do this again soon.